Many of these law firms have been able to be so successful, and the erosion here affects everybody. So thank you. I yield back.
Thank you. And now it gives me pleasure to introduce Ryan. You'll be happy to know another former Marine, but also someone, Ms. Young, who has been leading our inquiry into what the law firms are doing, is Senator Blumenthal.
Thank you, Mr. Chairman. There is no such thing as a former Marine, as we know. Semper Fidelis. And thank you, Mr. Chairman, for holding this hearing, and to both of you, Senator Schiff and Mr. Raskin. Thank you, Congressman Raskin, for joining me in seeking to shine light, and for your support, Senator Schiff, because America needs to be aware, needs to be afraid of what is happening here, and needs to know that there are people like you who took the risk and made the sacrifice that others far wealthier, more resourced, and more powerful were unwilling to take, members of our profession who declined to stand up and speak out. But here's the good news for America. There are lawyers willing to take on this fight against a bully. 504 signed an amicus brief. Others are representing the firms. Let's say their names: Covington and Burling, Perkins Coie, Jenner and Block, Wilmer Hale, who are trying to break this pattern. And it is a pattern. Donald Trump hammers, bullies, intimidates, and then offers to negotiate. He's doing it with law firms. He's done it with universities. He's doing it with countries and companies through tariffs. It is part of a slide toward tyranny. Tim Snyder, my friend, a professor at Yale, has said the first rule of tyranny from the 20th century, the first lesson is do not obey in advance. That is what Skadden Arps, Milbank, and Wilkie Farr have done. They didn't even wait for the executive order. They obeyed in advance. And I just want to make really clear what is most offensive to me. They acceded, in effect, to allow Donald Trump to tell them who their clients would be and who they would hire. I've been United States Attorney in Connecticut. I was Attorney General for 20 years, but I've also been in private practice. And if there's one thing that matters to me as a trial lawyer, and I still consider myself proudly a trial lawyer, it is nobody tells me what to do. And when I represent a client, it is 100%. And when I take on a client against a big corporation, and then some other big corporation or that corporation offers a great representation to me, I say, sorry, can't do it. I've got the little guy whom I represent, and I'll give up the bonuses and the wealth and the money and the billable hours because I believe in my profession. Donald Trump has boasted, and I'm quoting him, that he has built, quote, an unrivaled network of lawyers. These lawyers are in his pocket. And when they're in his pocket, they cannot represent that little guy. They cannot represent the individuals that Wilkie Farr did, that got them blacklisted. Ruby Freeman and Shay Moss, who volunteered as poll workers in Georgia in 2020 to help their fellow citizens vote in the midst of the global pandemic. He is depriving resources of people who really need that representation. And I'll tell you what strikes me as most abhorrent and repugnant, as reported in the New York Times, and Mr. Karp stated it. There were other law firms, and I'm quoting now from the New York Times of March 14th, some of the biggest competitors were calling top lawyers at the beleaguered law firm, one of the nation's most prestigious, asking if they would jump ship along with their lucrative clients. The firms are named Sullivan and Cromwell and Kirkland and Ellis. And Congressman Raskin and I are writing those two firms, along with the others, and asking them what they did to try to lure away those clients and partners, to try to poach their business and their resources. Most abhorrent to me is the potential that they acted in that way. Ms. Cohen, do you know of any specifics about attempts to take away lawyers or clients from either your firm or others that you may have heard?
Senator Blumenthal, I read the same report, and I think it's particularly ironic given that I'm also reading reports that Kirkland & Ellis is now in talks to acquiesce to the Trump administration in advance. So any clients thinking about jumping ship to any other law firm should remember that until they stand together, there's no chance that their new representation will be left alone either. But I will just say, I was a third-year associate when I left, and I wish you had someone more senior here to talk to you about this. But unfortunately, you do not, because the only people in this industry who have been willing to speak on this issue and give up their salaries in order to do so are associates, and I was not close to client work. But thank you for
I apologize for going over my time. I'd ask that the Truth Social and the New York Times story that I quoted be entered into the record.
Without objection.
And the distinguished lady from Vermont, Ms. Ballant, is recognized for her questioning.
Thank you to the chairs. First of all, I really want to acknowledge at the top the courage that it took for each of you to come here today. It shows an incredible amount of fortitude. These are incredibly scary times, and it's not easy to stand up and speak out against authoritarians. It's not easy to stand up and speak against the president. So all you have to do is look at our Republican colleagues, both in the House and the Senate, who are remaining silent. So the fact that you're willing to be here, to show your face, to speak up for what's right, it matters. And I have to tell you that this is a critical moment right now, and you are doing the right thing, even though it's frightening, because you're giving all of us just a little bit of hope in these incredibly dark times. Hope that we're going to be able to turn the tide on this. Hope that more people will see you and stand up to the corruption and the cronyism. And just a little bit of hope that we'll remember that who we are as a people, that we're beholden to the rule of law. And as my colleagues have said, that we are not beholden to a king or a dictator. So know that you are doing the right thing, even though it feels terrifying. Authoritarians like Trump have nothing but contempt for the democratic process and for due process. They mock the principle of accountability because they have none. They portray themselves as victims of so-called lawfare so they can discredit an entire system. That's what this is about. This is about discrediting the system. So we can't believe in lawyers. We can't believe in institutions. And that's terrifying. That is convincing all of us that the rot goes so deeply that the foundation of our very democracy can't be trusted. Ms. Cohen, in your resignation letter, which I have to say was such a shining light, you talk about fear and powerlessness that motivated some of these law firms in the country to cave. And that's what they did. They caved. They are bootlicking. They are bending a knee. Make no mistake, that's what's going on here. How is it that some of the most prestigious and powerful law firms in this country feel that they have to act in this way?
I wish I had a good answer for you, but when I read things like Brad Karp saying that it was an existential crisis for a firm whose profit per equity partner was over $7 million last year, I don't know what to tell you. I apologize.
That's right. That's exactly right. It's not an existential crisis where they're going to lose some money. We're talking about the rule of law. It's disgusting. And the courage that you have to be here when so many of your senior colleagues say nothing and grovel to a would-be king speaks volumes about your integrity. we're in strange times. There were protests across the nation. This weekend, the Chief Justice of the Vermont State Supreme Court, who, trust me, does not usually comment on political matters, he said, quote, "No prior administration has taken such concerted action against the bar. An effort to erode an institutional pillar designed to check abuse of power." When the Chief Justice is finding his voice and speaking publicly, you would think that some law firms could do the same when it's just about the almighty dollar. I want to conclude by saying Trump and all of his enablers, whether they're in Congress or whether they're at these law firms, seem to think that they can outrun this, that somehow we're going to ride this out. We're not going to ride this out. It's not going away. It's only when good people stand up and say, no, I refuse to bow. And my hat is off to all of you. You are showing courage that so many people in this moment are not. And I'm going to be able to go home this weekend, the end of this week, and talk to my two kids. I got 2 high school students, and they're going to want to know that there are good people doing the right thing, and I'll be able to tell them about this. I yield back.
Senator Hirono from the great state of Hawaii.
Thank you very much, and I thank all of you for being here. And obviously there were a lot of people here who really care about adherence to the rule of law, and I'm glad that I was able to make it for this portion. So I thank Congressman Raskin and Senator Schiff. So these are not normal times. We have a president who doesn't think that the rule of law applies to him, aided and abetted by a Supreme Court in their immunity decision. So what we have is a president who will go after anybody, including countries, corporations, law firms, anybody who he thinks can stand up to him. And basically, he is setting things up so that he can extort from them what he wants. And it is more than sickening to know that the people who are supposed to be standing up for the rule of law, I would say the lawyers, judges in our country, and we see many of them just, I would use the word caving, and that is why caving to the demands of this very corrupt president. So, Rachel, Ms. Cohen, thank you very much for having the courage, and for you to note that, it's too bad that none of the partners who are making millions of dollars at your firm would stand up to do the right thing. It's pretty pathetic. And for the 500 or so law firms that filed an amicus brief on behalf of Perkins Coie, I say aloha to them, because if we don't all stick together, we're all going to be divided and conquered. So thank you very much. And for each of you, some of you who I know worked for the DOJ, in fact, I think it's Ms. Young, you worked for the U.S. Attorney's Office, you work for the DOJ, you have a wonderful background. I remember when we had the hearing on Pam Bondi, because she has said at some point that we should go after the prosecute the prosecutors and investigate the investigators. During her confirmation hearing in the Senate, I asked one of the witnesses who came on the second day of her hearings, what would be an indication that she is in fact weaponizing the DOJ to exact retribution, etc. And this witness, who happened to be a law professor at Georgetown, my alma mater, and she said, "You're going to see people resigning, and that's what's happening, or you're going to see people being fired, and that's what's happening. All is not well in the DOJ." I did want to ask a specific question of Ryan Coswell. When Deputy Attorney General Tom Blanchard came before the Judiciary Committee, I asked him about why he was allowing attrition at a different part of the criminal division, the child exploitation and obscenity section, which fights child sexual exploitation. And he responded by suggesting that only U.S. attorneys' offices really prosecute crime and downplaying the role of criminal division trial attorneys in the DOJ. As someone who worked in both the U.S. Attorney's Office and criminal division, can you explain why having criminal division attorneys in D.C. is important and what we will lose if we gut the criminal division?
Thank you, Senator. What the criminal division litigating sections like public integrity bring is a degree of expertise. Mm-hmm. So certainly there are assistant U.S. attorneys around the country that can handle prosecutions of public corruption. We have a deep bench of very talented lawyers. They're experts in this. They can go all over the nation. And you mentioned that I have been in AUSA in other districts. When I was a prosecutor in San Diego from 2017 to 2020, I was prosecuting many immigration cases. And the entire time you had a public integrity section back in Washington. Hypothetically, if I had a situation where potentially a federal agent was allowing smuggling to happen because that agent was corrupt, I could call that public integrity section and get their help in prosecuting that case. And so if you worry about corruption, if you worry about abuse of power, it's good to have 30 or so attorneys who are able to take those cases on, which also allows the U.S. Attorney's offices to focus on violent crime, immigration crimes, fraud, predation on children. That's the value of it.
So obviously, the Justice Department is not particularly interested in preserving the expertise or keeping the expertise in all these areas within the DOJ, and they have their own agenda, which is what I would not call it the people's agenda. Again, for Ms. Young, thank you, for what you are doing. And in fact, when the AG Bondi and interim DC U.S. Attorney Ed Martin referred to DOJ attorneys as the president's lawyers. I think you were asked this question before, but do any of you, but especially for you, Ms. Young, do you consider the attorneys at the DOJ or U.S. Attorney's Office the president's attorneys? And if not, who are they attorneys for?
Sure. DOJ attorneys are absolutely not the president's attorneys. The president is free to hire as many attorneys as he wants. Attorneys at DOJ represent the United States and the American people, and that's it.
And to think that we now have a attorney general who says she is the president's attorney, and she's certainly acting in that way. So there you go. It's just entire takeover of, I would say, an institution, the Justice Department, that is supposed to be prosecuting criminals and doing the things that I know that all of you have been asked. I can't tell what the time is there. What is that?
The time is up.
Okay. Well, that explains it. But we have so many concerns, and again, I thank each of you for resigning, being fired, doing all the things that requires a lot of courage to do. But we just need to continue to fight back. Thank you,
Senator.
I recognize the distinguished gentleman from Illinois, Mr. Garcia of the Judiciary Committee.
Thank you, Ranking Member Raskin and Senator Schiff, for convening this most timely and important hearing to spotlight Donald Trump's assault on our democracy and legal system, and thanks all the witnesses for standing for justice and democracy as well in your respective positions. As an immigrant and an organizer who hails from Chicago, who's fought for civil rights and against machine politics for decades, I understand that the rule of law has always been a work in progress in our country. Even before Donald Trump entered the political arena, many immigrants and working class people have felt that the law was written and enforced to benefit the wealthy and well-connected at their expense too often. But in the history of this country, the president has ever weaponized the law to this extent. No president has done that before, for his personal benefit and in the service of outright authoritarianism. My colleagues have highlighted many important issues, and I want to focus on the administration's shameful and unlawful treatment of immigrants. There are too many abuses to name in 5 minutes. Trying to end birthright citizenship, which is written into the Constitution, attacking jurisdictions that have welcoming statuses, and which studies show lower crime rates and increased trust within those communities. Creating a draconian registration requirement, which goes into effect this week, by the way, on April 11th, detaining Mohammed Khalil and others solely because of their protected speech. And of course, lawlessly invoking the Alien and Enemies Act on false pretenses to detain people and spend taxpayer dollars to send them to a notorious prison in El Salvador. One of those people is Kilmar Abrego Garcia, a Maryland resident, father, and a metal worker, whom the administration sent to El Salvador despite Judge Boasberg's ruling and despite a 2019 court order specifically prohibiting him from being removed to that country because of the risk of persecution. Last week, the administration admitted that its removal of Mr. Abrego Garcia was a mistake. At a hearing on Friday, a senior career DOJ official, Erez Raveni, expressed frustration that the Trump administration had taken these actions and produced no evidence that Mr. Abrego Garcia is gang affiliated or that his removal was justified. The judge then ruled that the treatment of Mr. Garcia was shocking and illegal and ordered his return to the U.S. But instead of following the law, Attorney General Bondi suspended Mr. Raveni, and after the Fourth Circuit refused to block the judge's order, the DOJ has now asked the Supreme Court to step in, and it will. A ruling has not been entered yet on the merits of the case. In a sea of authoritarian lawlessness, this case stands out. So I want to ask you, Ms. Young, in your experience and based on public reporting, do you think Mr. Raveni's actions warrant suspension?
Absolutely not. And I know Erez Raveni, he is one of the most zealous advocates in the entire department, but he would never violate his ethical duties, including candor to the court.
What does his suspension tell you about DOJ leadership and its credibility?
It tells me that it values loyalty over the law, and I question DOJ's credibility right now.
And do you believe that what DOJ has done to Mr. Abrego Garcia represents a miscarriage of justice?
I am not going to comment on a legal question like that.
I understand. Thank you for that. We're living through one of the most shameful moments in our country's history, and it's incumbent on every one of us to fight back against this lawlessness. Your presence here is an important signal to the rest of the country that we are doing that. Thank you again, Ranking Member Raskin and Senator Schiff, for convening this hearing. I yield back.
Thank you, Senator Welch from the great state of Vermont and a great champion of the rule of law.
Thank you. And it's wonderful to see my colleague from Vermont here, Representative Ballot. Thank you. But it's mostly wonderful to see you here. Yeah, I'm interested in talking to you about why you became attorneys and the culture of law as you saw it and what you experienced. I'll start with you, Mr. Crosswell. You know, it's so amazing, the code of kind of, you're a Marine and a lawyer. Duty, honor, loyalty. I mean, just talk about the culture and why a culture is important. Not just personal values of an individual, but an individual is part of a team who's part of a culture that is the responsibility, when you're in that, to reinforce the positive values. Just talk to me a little bit about that, and then how that was challenged with what you faced.
Thank you, Senator. You're right. My first job in public service was a Marine officer, and you're taught to always take the hard right over the easy wrong. And As an officer, you teach the people that you lead the same thing. That also applies in any law firm office, any prosecutorial office. It's about culture. Because when you work for the government, you have an enormous amount of power.
Right.
You have to be a check on yourself, so to speak. And so when I was in the Marine Corps, I defended Marines accused of crimes of courts-martial. And there were certain clients that I got acquitted at trial. They were found not guilty. That wasn't because the prosecutors failed at their job. That was because they did their job, because they provided me with the evidence where I could defend my client. That's how it's supposed to be done.
Right.
And we need that in every U.S. attorney's office.
No, thank you. Ms. Oyer, that's an incredible decision to resign, and it's resigning from a job you love and working with people that you respect and admire. And then obviously the personal and professional implications that you're going to have to deal with for some time. So obviously there was a commitment to a culture that you saw being breached, and I'm going to ask you just to elaborate a bit on that.
So I was actually fired. The decision was taken out of my hands.
Well, you knew what would happen.
Yes.
You were fired. Yeah, I'm sorry.
My role in the department was becoming increasingly untenable every day. It was becoming more and more difficult every day to do the job in a way that was consistent with my values and my obligations as an attorney. And honestly, on some level, it was a relief to be fired, to take the decision out of my hands,
Right.
although it required me to leave behind a mission that I cared deeply about and a team of people who I care deeply about. And I take some heart in the fact that they are still there carrying on the good work.
And you literally had a couple of armed marshals en route to your home when your teenage child was home alone?
That's correct.
Yeah, I'm going to go back to you, Mr. Crosswell. Do you treat subordinates that way? I mean, is that at all acceptable?
No, Senator.
All right. And Ms. Cohen, you were friends with our beloved Mr. Raskin's son, and we've heard a lot about him. And I can only imagine the kind of commitment to public service you had, and found a way when you accepted an opportunity to work at a major and prestigious law firm. Tell me about how you saw being in Skadden Arps, a major Wall Street, really world law firm, as being also an opportunity for you to live your values as an attorney, your commitment to justice, and also have an opportunity to work for folks who otherwise wouldn't be represented.
Absolutely. In part, I'm realizing that it was just very good marketing, but I do think that while I was on the job, I had unlimited pro bono hours. It was perhaps the most important thing to me when selecting a law firm, because I wanted to get trained up on the private sector things. My past work was in public education, and I needed to understand how those things work. It drew me to finance, but I devoted anywhere from 20 to 33% of my hours to pro bono every year. And ultimately, that is why I resigned. I'd love to say it was an abstract rule of law, anything else, but I did a decent amount of immigration pro bono representation, and actions by this administration are making it very clear that that is soon going to be viewed, or already is viewed, as adverse to the administration, despite the fact that it is just to allow people to survive when they are fleeing harm and persecution and death. And I couldn't stay at a place that I knew was on the verge of not allowing me to take representations that the president viewed as adverse, knowing what he views as adverse to him.
Right. Well, thank you all very much. Thank you. Thank you.
Thank you, Senator. I want to thank all of our witnesses for testifying today. Everyone in this room grew up in a period since World War II where we were used to seeing a world that was ever increasing in its freedoms. We saw walls come down. We saw new nations born. We saw the ever greater ability to express ourselves, to practice our faith, to associate with whom we would. And we came to believe it was inexorable. We came to believe that it was like the laws of gravity. Or it was, as Martin Luther King said, the moral arc of the universe always bending towards justice. until all of a sudden it wasn't bending towards justice. And we've come to realize, much to our shock, that there's nothing inevitable about this. There's nothing inevitable about democracy or democratization, that this experiment in this country, this great experiment, self-governance, now 2.5 centuries old, is not inevitable. It was improbable at its start. And we've witnessed something we never would have imagined in this country. We have witnessed with incredible rapidity the creation of a climate of fear by this administration. We see universities afraid to speak out, to defend their own students, to defend their own academic freedom. You see universities rushing to make deals with the administration. You see universities cowed into silence, not stepping up to defend other universities. You see members of the press excluded from public events because they don't use the administration's favored parlance. And you don't see other members of the press in solidarity with them. You see law firms rush to cut separate deals. You see lawyers purged from the Department of Justice. You see FBI agents purged from the Bureau. You see scientists purged from their agencies. A wholesale effort to weed out and drive out anyone of independent thinking, anyone who will stand up and defend the rule of law or science or the freedom of thought or expression, right down to ordinary citizens who are now afraid. If the government of the United States can pluck a man off the street and send him to a prison in El Salvador without any kind of due process or any process whatsoever, then no one is safe. And if the government's response to that is to discipline a lawyer who dares to speak the truth to a court, then no one is safe. And the answer to this climate of fear, there really is only one answer, and you're seeing it today, and that is courage. We must demonstrate courage in the face of this fear. In this very committee room, or one like it, Joseph McCarthy and his allies made the country afraid and caused people to inform on each other and betray each other, allowed people and to be driven out of the government and to be persecuted. And we wondered how that could be. We wondered, how could so many people be complicit? Well, now we know. Now we know. Now we have witnessed it in our own time. But I will say this of the brave witnesses who have come and testified today. All of the rest of us have to ask ourselves, looking back at the McCarthy era, what would we have done? What would we have done if we were faced with the loss of our jobs, if we were faced with the loss of our livelihood, if we were faced with the loss of our position? What would we have done? Well, you don't have to ask that question. Your being here is all the answer anyone could demand, and we are deeply, deeply grateful to you. I yield to my colleague and friend, Jamie Raskin.
Thank you, Senator Schiff, and thank you for your leadership. It's been an honor to conduct this proceeding with you, with all these wonderful guests and everybody looking at the proceedings across America. And thank you to our great witnesses here. Ben Franklin once said, "Make yourself a sheep and the wolves will eat you." And you are four people who have not made yourselves into sheep. You've shown us how to stand tough and stand strong against tyranny and despotism. And you and all of my colleagues here are speaking today in the spirit of our Constitution. We have an anti-monarchical Constitution. We've got no kings here. We have the freedom of speech. We've got no queens here, no emperors here, and we have no slaves here, and we have no serfs here. Just people, citizens, all of us together, standing equally under the Equal Protection Clause. We have an anti-monarchical constitution. It forbids titles of nobility. It was so important to the framers. Congress cannot award or recognize titles of nobility. We've got an anti-cruelty constitution. The Eighth Amendment bans cruel and unusual punishment. We've got an anti-corruption constitution. It guarantees due process to everyone. It guarantees equal protection under the laws, as well as freedom of speech and freedom of the press and free assembly, the right to petition government for redress of grievances, free exercise of religion, no establishment of religion. And so we say to the courts, as Ms. Cohen said, you're an important line of defense. I don't think that you're the last line of defense. I think the people will always be the last line of defense, but you're a significant line of defense for us right now. We have 68 court orders that have been rendered by federal district courts, preliminary injunctions and temporary restraining orders against all of the lawlessness that's taken place. And we hope that the U.S. Supreme Court, which we know Donald Trump bragged about having packed and stacked in order to overthrow Roe versus Wade and get the Dobbs decision. We know that the court may be in a different posture on some of these things, but we ask all of the justices to live their oaths of office to uphold the Constitution and the rule of law. I ask them, I ask everybody in Congress, I ask everybody in the country to go back and read the steel seizure case from 1952, where President Truman ordered the seizure of the steel mills in the middle of a war, in the middle of the Korean War. He said it was a national security crisis and we couldn't afford to have a strike and a standoff between the unions and the management. And so he just ordered that all of the steel mills be seized. And the Supreme Court came back with a remarkable decision saying the president gets his power only from either the explicit text of the Constitution or from Congress. And Congress had already rejected the idea that the president should have the power to seize the steel mills. And so the court said in a 6-3 decision, the Constitution doesn't grant you that power, and Congress forbade you that power. And Justice Jackson, in his famous concurrence, said, at that point, your power, Mr. President, is at its lowest ebb. But here's the remarkable thing about the decision, which is indeed the paradigm for interpreting executive power. As Justice Amy Coney Barrett said in her confirmation hearings over here in the Senate, the remarkable thing about the decision is that there were 9 Democrats, most of them New Deal liberal Democrats, on the Supreme Court at that moment. President Roosevelt had been in for 4 terms. Truman had come in. These people, they were friends. A lot of the justices had served in the Roosevelt administration or in the Truman administration. Some had been in the Department of Justice. And in fact, the 3 justices in dissent taunted them, saying, you said this was totally fine. You wanted this to be a power that the president would have. And now you're on the court and you're saying the president does have this power. But it was really their finest moment because they distinguished their roles as partisans when they were either in Congress or in the administration from their role as justices upholding the Constitution and the rule of law. And they said, despite the fact that this was their team, they could not allow the president to overstep his bounds in that way. And after the case was rendered, Justice Jackson was so nervous that President Truman would never speak to him again that he had a dinner party with all the justices, and he invited President Truman to come over there. And there was a round of toasts, and Truman said to Justice Jackson, well, I don't know if I like your law that much, but this is a hell of a good bourbon you're serving us tonight. So we hope that the justices will live up to their titles. They're the only jurists in the federal system who get the title of justice. Everybody else is a judge, and we hope these justices will act with justice. And I want to just say finally about the law firms, because I've been working with Senator Blumenthal and with Ms. Scanlon on the question of the law firms. There is no safety in appeasement. There just is no safety